Hey guys, this is my model answer for diminished responsibility. This goes alongside murder. So if there's a murder in a scenario, which most likely there will be, you write this answer out and you will get a sound. So, blank could raise the defense of diminished responsibility. Do brackets, then dr, close brackets, then you can just refer to it as dr throughout the whole essay. DR is a statutory defence and comes under Section 2, Subsection 1 of the Homicide Act 1957, as amended by Section 52 of the Coroners and Justice Act 2009. A person who kills or is a party to a killing of another is not to be convicted of murder if suffering from an abnormality of mental functioning, a state of mind so different from that of an ordinary human being that a man would term it abnormal, as stated in Byrne, which, so there's brackets there, abnormality of mental functioning, which A, arose from a recognized medical condition. In Byrne, the sexual psychopath's inability to control his perverted desires could plead DR. In Reynolds, a young mother killed her own mother with a hammer. Postnatal depression was enough to argue DR. In Speak, mental deficiency was accepted as an abnormality of the mind. In Martin, the defendant's paranoid personality disorder was accepted as DR. So that goes from the first step of arose from a recognized medical condition. Secondly, it must have substantially impaired the defendant's ability to understand the nature of his or her conduct, form a rational judgment and exercise self-control. In Lloyd, the court said that impairment need not be total but must be more than trivial or minimal. In R.V. Khan, it was ruled that it is impossible to provide any accurate or scientific measurement as to the extent to which a particular person may be able to understand or control their physical impulses on a particular occasion. Sorry, couldn't even read what I'm writing there. So that goes through the second step nicely. Last step, or second last, depending on scenario, provides an explanation for the defendant's act and omission in having or being a party to the killing. Section 1, subsection B of the Coroners and Justice Act 2009 states that abnormality of mental functioning provides an explanation for the defendant's conduct if it causes or is a significant contributory factor in causing the defendant to carry out his conduct. And if there is intoxication present, you would have to refer it to as alcohol dependency syndrome, an abnormality caused by taking drugs or drink will not suffice. You can mention the case of Dowd's, although alcohol dependency syndrome will suffice, as it is a medical condition. So being drunk will not, but if there is another cause to the abnormality, then the jury must ignore the drink and concentrate on that. Mention these three cases and you should be fine. So Dowd's, Tandy, Wood and Stewart. That's about it, to be honest. This will get you an A. 100% guaranteed it will, because I've done it before. Just make sure you do sufficient application after each of the steps. The steps are A, B, C. Make sure you mention and define an abnormality of mental functioning, refer it to the case of Byrne, introduce it nicely like that, and you should be on your way to a sound grade providing you have sufficient application. The cases are enough here, I think, so there's 4 here, there's 2, Lloyd and Khan, gives a nice reference to section 1B, and you've got 4 additional cases if you want to use them. You can use Deichmann as well, that's a pretty relevant case to this, but overall this should be a sufficient answer enough to order you and secure you a sound. If you have any other requests, please do mention them below. Twitter's down below if you want to tweet at me, give me a follow, I don't mind. Yeah, this should be sufficient enough to give you a sound as I mentioned, and take care guys.